right, good afternoon everyone. Two members are still missing, but I think we should proceed. I don't want to waste more time. We don't have much to begin with. We finished off with pre-trial procedures, witness statements, Rule 92. We discussed that at length before the lunch break. So essentially you should know what it must contain, when it must be filed, subpoenas for, I'll speak about subpoenas in a moment. It's not in the form of an affidavit, it's in the form of a statement. It becomes evidence when it's read into the record by a person who is, by that person on whose behalf the witness statement is filed, and when he or she takes the oath and takes the stand, constitutes evidence in chief. You can cross-examine a party on his or own witness statement, but not on others' witness statements. And then, of course, I've also referred you to the judge having to admonish the witness before reading the witness statement into the record. Subpoenas. So it happens that parties need the evidence of witnesses who are not available to give witness statements. Therefore, parties are required in the case management or in the pre-trial order to set out the names of the witnesses who that party intends to call by way of subpoena. When a witness is subpoenaed, then that witness need not file a witness statement. Now, of course, the rule cannot be abused in the sense that you can avoid filing witness statements by just subpoenaing witness. You can't subpoena yourself, and of course the idea is that you subpoena witnesses who are independent from you, not an employee, not a relative, not closely involved. So it would really be an outside party whose witness statement you cannot secure in the normal course. Okay. So that takes care, well, maybe just have a look at the expert witness statement. So you must remember to distinguish between an expert notice and expert summary, which we dealt with earlier, and then the actual expert witness statement. So you'll find one on page 153 of the bundle of pleadings that you were given, the example. We've now already established that the witness statement in that bundle is a non-compliant, well, is not compliant with the rules. So you will still be able to cross-examine a witness on the testimony of another witness, but you can't cross-examine him or her on the witness statement that hasn't become evidence yet. But once a party has given evidence, you're not cross-examining on the witness statement, you're cross-examining on the evidence of that party. But that you're not precluded from doing, and I can only think that the rationale behind that rule that disallows you is because that's not yet evidence before court. You don't really know what that party is going to come and say. He or she might actually change their version, say this is wrong, this isn't correct. You don't know, or that witness may never even be called. So the problem that you have is that it's not on evidence yet, but once the evidence is given, I cannot see how you can preclude a party from cross-examining on that. So it's just while it's still a witness statement that isn't evidence yet. Okay. So Rule 92 deals with witness statements. You will see the witness statement by an expert, again setting out. It's much like the summary, and it basically sets out what the expert's qualifications are, how he conducted his examination, and how he arrived at the opinions and the conclusions that he arrived at. And it would obviously refer to a report more often than not when you have experts like medical experts or actuaries or so, you'll have reports that they also attach. You could, in terms of the previous rules, there was a specific provision dealing with that and saying that a party could seek very specific discovery of documents before plea. The new rules don't make provision for that. That's not been included in the rule for discovery. You can read the rule. I've read over it a number of times. I can't find it there. Maybe I'm blind to it, but I can't find it. It's not in the new rules. That's not to say that you won't be entitled to, because remember, the rules are there for the court's not there for the rules. The High Court has inherent jurisdiction, and it can, by necessary implication, then regulate its own process. So essentially, one would expect that when a party makes application to the court, to the managing judge, at case management stage already, which is something we did recently in a matter where we had to plead to certain to particulars of claim, where certain documents were required in order to plead. It was about an insolvent estate, and it was not an insolvent estate, it was a company in liquidation, and it was one of those instances where an alienation of property was sought to be set aside as immediately after the alienation of the property without value. It was a donation. The company's debts exceeded or liabilities exceeded its assets. And so obviously, in order to be able to plead thereto, we would have to have insight into the financial statements. So in the case plan already, the parties discussed this. Okay, in that case, the parties agreed to make that discovery available so that we could plead to that. But at case planning, surely a party would be able to say, I need to have discovery of this or that or the other document. It's not a blanket discovery. It will be relating to specific documents. So your answer is it's not specifically catered for in the rules by notice it previously was, but that doesn't mean that it can't happen. I suppose it would be possible. You can see whether you can couch it possibly in the same terms as Rule 28, Sub-Rule 8, but I'm not sure that that'll actually work. That's in the spirit of case management and the obligations of case management. So it doesn't set out a procedure, but you're quite correct. When we deal with the objectives of case management and the ethos of the civil litigation system in Namibia, then that, of course, is a relevant consideration, that you should make discovery. And the overriding principle would be the interest of justice, the administration of justice, and, of course, granting a party a right to a fair trial, which is a constitutional right. So the short answer is it's possible. It's always possible. Anything is possible. All right, let's then proceed. Indexing and pagination, practice directions. Indexing and pagination is not something that's done by the court. It's something that's done by the parties. It's dealt with in the practice directions. I'm not going to be spending much time on how, when, where, and whatever. I myself don't ever index and paginate court files. That's left to instructing practitioners. It's done by the party who is dominus litis. I suppose you all know or are familiar with the term dominus litis. The dominant litigant, so that would be the plaintiff or the applicant, the party who's driving that particular litigation. So if it's an interlocutory brought by the defendant, the interlocutory proceedings need to be paginated and indexed, and that would mean that the defendant would have to index and paginate the interlocutory proceedings pleadings. Indexing and pagination, and when it's done, is dealt with in the case management process. There's usually an order to that effect, and then the party needs to do or comply with that. Now, you must understand we have e-justice and we still have old paper files. So for e-justice, it's done on the system. The indexing and pagination is done on the system. It's something that I think practitioners are still learning. So some of them are quite competent with this, and some of them are still struggling. But essentially, e-justice gives you the option to index and paginate. Paper files, you physically go to court, get the file, sort the papers, paginate them, and index. File and index them. So you'll file in either way. You'll draw up an index stating these are the pleadings, these are the notices, and these are the other documents, because it will be in these three sections, and it follows chronologically. Some judges prefer, well, I mean, that really depends. As long as it's in these 3 sections and it's chronological, you're in compliance. Pleadings, notices, other documents. Okay. Then practice directions. They are subordinate legislation in the sense that it's not an act of parliament. It's like a regulation. It really what it does is to guide and elaborate on how the rules are to operate. You need to be mindful of what's in the practice directions, and where there's a discrepancy between the practice directions and the rules, then the rules will, of course, enjoy precedence. Managing a court diary, I suppose that's a very difficult concept, especially from a judge's point of view. I can tell you that a judge, I suppose, can easily, or a diary, a judge's diary, can easily go haywire because of parties, because of litigants. What in practice happens is interlocutory matters are set down for an hour in the mornings. Parties are limited, unless, I mean, there are exceptions. Certain interlocutory applications can be very complex, in which case an hour in the morning probably won't suffice. But for the run-of-the-mill type of interlocutory application, you would be able to do that in a morning, in an hour, and then proceed with a trial or whatever. That's just to get as much as possible flowing and through the system. Case management, while some judges tend to be very effective with case management in the sense that time effective, very quick, some of them tend to spend hours on case management. That really is something that is a personal issue, a personal approach to matters that depends from person to person. Essentially, I suppose the golden rule is don't overload a diary. The more you overload your diary, the less time you'll be able to deliver judgments, which is really what you are there to do. Be strict with litigants regarding a diary, and if litigants become aware that a certain judge is very lenient in just postponing matters and moving, shifting, and then they will most certainly take advantage of that every possible time or place that they can. That's how it works. But managing a court diary, I don't want to say too much. That is really something I think that the other judges will speak to you about. The inner workings of a judge's diary is not really something that I'm acquainted with. Delivery of judgments. Of course, the idea is to deliver judgments as quick as possible, but to not, in the process, forego quality. It's very important that from the High Court we get a body of case law that forms our own common law and that dictates the position that is significant in Namibia and that we need to or can use going forward, and which will then mean that we have to less and less rely on authorities from other jurisdictions because we have our own body of case law. So delivery of judgments and the practice directives, I think the Deputy Chief Justice has discussed that with you in his opening lecture, and you'll deal with it more. So I'm not going to belabor the issue. Just know that there are certain benchmarks and expectations of judges in respect of the delivery of judgments. And of course, the longer you take to deliver a judgment, the more difficult it is. That for you as a judge. That's the reality of it. So procrastination is probably not in your favor. Okay, cost awards. Essentially, the golden rule with cost awards is that it's within the discretion of the court whether or not to award costs. And then the normal principle is that costs follow the event. So generally, a party who is successful should also normally be granted a cost order in his or her favor. the question is, can costs be ordered or awarded where it's not sought? The answer should probably be no. Well, if I'm successful and the court is angry at my opponent for doing something or not doing something, and I say, but I don't want a cost order, can the court then still grant a cost order? Can the judge go on a frolic of his own and just grant the order? So the answer would probably be no. I think there's a reference, if I recall correctly, I'm not sure whether it's a Kleinhans matter. It's a Supreme Court judgment where the Supreme Court expressed disapproval at the way a practitioner or two practitioners had handled a matter in the Supreme Court, and wanted to grant a cost order de bonis, but then didn't do so because there was no request. I'll check for the citation tonight. I think it's the Kleinhans matter in the Supreme Court. Anyway, so the court expressed its disapproval at the way in which these practitioners handled the matter. It was the one non-compliance on the other, and as a result, the court said, well, I wanted to give a de bonis order, but because it wasn't sought, I'm not going to give it. I'm not sure whether it was the Kleinhans matter. But anyway, I know the practitioner involved, so I will go Google tonight and see if I can find the reference for you. So generally, no. If a cost order is not sought, even though a party is entitled to it, I wouldn't think that it's proper to grant an order that's not sought. There are a number of manners in which a cost order can present itself. So you'd have, in the normal course, all other matters being equal, you would have cost follow the event. So the successful party would have a cost order in his or her favor, and that cost order would be on a party and party scale. Party and party scale merely means that the costs that are awarded are in accordance with the scales in terms of the rules of the High Court, which means that it's probably less than what the actual costs are that party has expended, but it's in accordance with the rules. So it's taxed. The taxing master would look at all the steps taken in the litigation, all the reasonable, necessary steps. So not everything. If you are an overachiever and you've drafted heads of argument where they were not required, then that's going to be for your pocket. It's not going. The other side will not be required to reimburse you for that. So all the steps necessary, reasonably necessary within the course of litigation, and then the cost associated with that. So if your counsel charges you 10 hours for reading 2 pages, that's not to say that the taxing master is going to allow 10 hours. It will be a per page type of approach that's done. So a bill of cost is drawn with your high watermark. It goes to the taxing master. The other party is there, can make representations, can say, well, you seek 10 hours for this, but it's just a 2 pages, so you're only entitled to this fee, for instance. Or your counsel is 10,000 an hour, but the maximum, for instance, I think is 1,800 per hour. So previously, counsel's fees just became a disbursement that's attached to the end, and no one taxed that. Now everything is taxed. All right, then there can also be attorney and client, or attorney and own client costs, which is a higher scale. It still probably won't recover all costs, but it's at least it's a higher scale than the party and party costs. Those costs are awarded usually as a punitive measure to say, well, you have been so vexatious, or you have been so non-compliant, or I'm expressing my dissatisfaction at you by giving a cost order on an attorney and own client scale, granted that it has actually been sought. Or it can be, for instance, in terms of an agreement. Often agreements say that when one party has to go to court to recover any monies in terms of the agreement, then it would be entitled to a certain interest, and it will be entitled to attorney and client costs. So those are the instances. Then you get what is called a de bonis properis order. This word gives lawyers nightmares or sleepless nights, because that's where a court when costs are sought. So I'm now the plaintiff, and I go to court and I seek a cost order against the defendant. And the court listens to the whole story, and the court is of the view that it's probably not the defendant, but his or her lawyer or attorney or legal practitioner or counsel who is to blame. The court will say, I want to give a cost order, but I want to give it against the legal practitioner. It happens often. Then the court says, I want to issue a de bonis properis order. Now, of course, what the court would have to do in order to do justice is to give parties, or give that practitioner at least, an opportunity to make representations as to why a de bonis order should not be granted. So de bonis properis order is against the lawyer. The court says the lawyer will pay and that can be on a party and party scale or attorney-client scale. De bonis properis means you as lawyer, you are going to pay the costs. Then please be mindful of instructing and instructed counsel. So instructing counsel would be what we call a lawyer, and instructed counsel would be what we call an advocate, although we are all legal practitioners, plain and simple in terms of the Legal Practitioners Act. So instructed counsel is someone who is instructed by another legal practitioner. So I operate under what is called a Fidelity Fund exemption certificate. Therefore, I don't work directly with members of the public. They come to me through a lawyer who has a Fidelity Fund certificate. And I send my account to the attorney, and the attorney then pays me. I don't take money from the public either. I don't have a trust account. I don't need to have one. I'm not allowed to receive money from the public. So that's the difference between instructing and instructed counsel. And if you don't seek an order for both instructing and instructed counsel, you probably won't get it. More importantly, the court will take the complexity of the matter into consideration and won't always. Is the aircon on? My word, and this thing is blowing hot air like you won't believe. Okay. The court will not in all circumstances simply order instructing and instructed counsel costs. It'll depend on the complexity of the matter. So you may, as a litigant, want to have a senior and a junior counsel there, 2 instructed counsel and 1 instructing counsel, but it's only a summary judgment application. The court will not grant you all those costs because it's not reasonable. If you're successful, it's not reasonable to expect your opponent to pay for the fact that you wanted 3 counsel in a matter of such little complexity. So generally, that's the approach. Can I also ask you for some water? Thank you. So generally, that is the approach to instructing and instructed counsel. Then taxing costs. I've just explained to you how that works. It's a process. The only way in which the taxing of costs would come to court would be if someone takes the decision of the taxing master on review. So the taxing master allocates a certain amount, having gone through everything, and either party is unhappy with that and feels that there's a ground for review. Sorry, because there's been a misdirection of some sort by the taxing master, then it will be taken to court on review. Doesn't happen often. I have seen it happen. Then you need to look at Rule 20 and also be mindful of Rule 32.11. I just want to take you there. So Rule 20 is protective cost orders in cases of public interest. It's a protective cost order in certain instances. It's where matters of such magnitude that it's in the public interest, etc. It's a protective cost order, which will prescribe in advance that there will be no order as to cost in the substantive proceedings, whatever the outcome, or prescribe in advance that there will be no adverse cost order against the party requesting the protective cost order in case that party is unsuccessful in the substantive proceedings, or cap the maximum liability for costs against the party requesting the protective cost order in the event that that party is unsuccessful in the substantive proceedings. If a litigant covered by a protective cost order refuses an offer of settlement and fails in the event to be awarded more than the offered amount or remedy, the protective cost order does not apply only with respect to the proceedings up to the date of the offer of settlement, and the court may make any award regarding costs that it considers fit in respect of an application for protective cost orders under this rule. Okay. So where a party goes to court on a matter of public interest, he or she can be protected by way of an advance cost order. Yes, for example, constitutional matters. Now, it refers here to an offer in settlement. Maybe just mention briefly, it's also perhaps something you're not acquainted with. If you party can do in terms of the rules is to make an offer into court for settlement. Now, this offer, the specific rule dealing with it, I think it's rule, let me just take you there. It's rule 64. It's an offer to settle, and rule 64 allows a party to make an offer in an action where a sum of money is claimed, either alone or with other relief. The defendant may at any time, and remember now this is the defendant in the main action, it would also be a plaintiff in a counterclaim. It applies to both, may at any time unconditionally or without prejudice make a written offer to settle the plaintiff's claim, and the offer must be signed either by the defendant or his or her legal practitioner if the latter has been authorized in writing to sign. Okay, same with specific performance. It may make any party, sub-rule 3, any party to an action who may be ordered by court to contribute towards an amount may also make an offer. Notice of an offer or tender in terms of this rule must be given to all parties to the action, and it must state whether the offer of or tender is unconditional or without prejudice as an offer of settlement, whether the offer or tender is accompanied by an offer to pay all or only part of the costs. It's made by way of settlement of both the claim and the costs, or the claim only, and whether the defendant disclaims liability for the payment of costs, etc., etc. And then there's 10 days within which you can accept the offer. And what happens is this offer is not brought to the judge's attention. If then the matter proceeds and judgment is subsequently given for an amount less than the offer, it would mean that then the offer would be brought to the judge's attention, and that would have a cost effect. It would mean that from there, the party who proceeded and didn't accept the settlement offer would then not be entitled to costs from that point onwards, from the point when the offer was made. You see? Okay, so when an offer is made, it's not brought to the judge's attention, to the court's attention. Then the matter proceeds if it's not accepted. If then ultimately judgment is granted for an amount less than the settlement amount, then that party will bring, the party who made the offer will bring the offer to the court's attention and will say, I made this offer which is more than what you've ordered, it wasn't accepted, so as a result, this party who didn't accept the offer, who now got an award of less, should be deprived of costs from after the offer was made, because you proceeded and you should have accepted the offer. You follow? So for instance, I and you, so I think it's a reported judgment. I once acted for a defendant. He, just a bit of a strange scenario. You can go and read up on it. So this gentleman was in a romantic relationship with a lady, and she was going through a divorce. And so you can imagine the animosity there. So at some point, the lady needed to phone her almost ex-husband regarding the children, and he didn't want to answer the phone because they were not speaking to each other. And so this other gentleman, who was now in the romantic relationship with the almost ex-wife, sent the almost ex-husband a text message saying, answer your phone, you, and then he said a very crude word. And so this almost ex-husband sued the new boyfriend for damages. And so, I mean, we could hardly get away from the fact that my client did send that text message. I mean, so we could explain it away and we could say, well, this was the situation between the parties and this, that, and the other. But at the end of the day, you don't go around calling people that. So essentially, I said to my client, you know what? I've looked at the case law. Calling someone by this name, I suppose, would be an offer roundabout, or would be amount to an award of round about 1,500, 2,000 Namibian dollars. So I'd say, and this was an action in the High Court, so they claimed something like 100,000. So I said to my client, you know what, make an offer into court for 5,000 Namibian dollars with costs up to this point. And my client did that. I mean, he was financially able to do that. And we did that, and essentially the court granted an order. I can't recall, it was Judge Smuts was the judge. I think it was about 1,500 Namibian dollars that he ordered, or 2,500, which is obviously less than the offer that we made, which meant that this guy ended up paying my client. He got the order of 5,000 or something, of 2,500, I don't recall, but at the end of the day, he ended up paying my client's cost in the amount of 50,000 Namibian dollars. So not much of a victory, I suppose. So these things come in handy at times. You can go read up on what happened there. Anyways. All right. So always within the court's discretion, different scales, taxing of costs, Rule 20 and Rule 3211. Just be mindful of the fact that Rule 3211 caps interlocutory cost orders at 20,000 Namibian dollars. It's still within the discretion of the court. There's case law that suggests that a party is entitled to seek a direction from the court that Rule 3211 will not apply. And the court will take things into consideration, such as both parties having two instructed counsel, both parties complex issues, heads of argument were required, which usually are not required in interlocutory proceedings in order to keep the costs down, etc., etc. These are the things that the court will take into consideration. All right, so any other questions on cost orders? Law of cost is, don't underestimate it. It is a complex field of the law, and it's something that judges will have to know fairly well in order to make the cost order, because it's in the discretion of the parties, of the court, not in the parties. So, but I just wanted to touch on that. No, it's not exactly the same. There is a slight difference, but essentially, the end of the day, it'll make little difference in the taxation. So there's some case law that suggests that attorney-owned client is almost everything you charge. You are charged by your own counsel, but then there must be some pre-agreement between the attorney and client, but that hasn't really been settled in our jurisdiction. So there is a difference. You can have a look at the law of costs. There they deal with the different issues of attorney-client, attorney-owned client, and what these are. Okay. Then we get now finally to, this is a slide from yesterday, you'll recall, but we are now at judicial case management. JCM. Judicial case management happens in 3 steps. Now, we've said yesterday, case plan before close of pleadings, these 2 after close of pleadings. Okay. What sets this whole process in motion, judicial case management, what sets that in motion is when a notice of intention, when it sets it in motion for actions. Remember, there's also judicial case management of motions, but I won't be dealing with that. So I'm only dealing with judicial case management relating to actions. So what sets that in motion is a notice of intention to defend, automatically leads to case management process. So once action is defended, it goes to case planning. The judicial case management process is set in motion by filing a notice of intention to defend. Okay, so the objectives of case management you will find in Rule 17 and Rule 18. Now, I strongly suggest that you spend some time with Rule 17 and Rule 18 because these tell you why we are case managing. So before we get to that, perhaps the concept of judicial case management may be slightly foreign if you have no experience in the High Court, simply because how it used to be is that parties used to issue summons and the action would run its course, and the parties would take such steps as in terms of the rules as they saw fit, and they would agree amongst themselves, and they would take as long as they needed, and they would do whatever they wanted. And then at the end of the day, when pleadings have closed and discovery and all of that's taken place, there was an old Rule 37 conference. It was really you would file a Rule 37 minute, which really was a one-liner saying the parties met. In terms of Rule 37, it was actually just going through the motions. And then the matter was set down. And once the matter was set down, it was sent to a judge, and then the judge would get the matter shortly before it goes to trial, unless there are interlocutory motions that were set down before a judge. There was no managing judge allocated. The file was really floating around in the registrar's office, and whomever was available was then allocated the file. So the parties really were in control of this process. There were no such things as witness statements and the like, so parties came to court and no one knew what witnesses they were going to call and what these witnesses were going to say, and so it was really quite a surprise sometimes when your opponent pitches up with 10 witnesses and you had to hear during examination in chief for the first time what these witnesses were going to say. That all has changed with the case management system, and what essentially happens is the role of the judge has changed from sitting there and waiting for the parties to come to the judge to say, we are now ready for you to hear this matter on trial. The judge takes control of the matter, and now please be mindful of the fact the judge does not go down into the arena and become the litigant. And it's very important to remember that a judge must remain impartial and must guard that impartiality fiercely throughout the proceedings. So even though a judge may be intimately involved in the management of that matter throughout, the judge should not become involved in the matter in such a fashion that his or her impartiality becomes an issue. Essentially, what the judge does is to say, I am going to make you get your ducks in a row, but I'm not going to get them in a row for you. You as litigants, you are going to get them in a row, and you're going to get them in a row by doing this, by these times. And if you don't do it, then I'm going to close the doors to you, because then you are wasting everyone's time. So the judge becomes the controller of the logistics of the matter. That doesn't mean that the judge in any way litigates on behalf of a party or suggests how a party should litigate, etc., etc. The judge merely becomes the person who drives the matter to be ready for trial, to be ripe for trial. A judge's role in actually attending to the trial hasn't changed much, although certain things may crop up during trial, which will then still be guided by these principles of case management and the ethos of the new civil system. So a judge is still removed from the proceedings in the sense that when the parties conduct the trial, they would be given the leeway to do so. A judge doesn't interfere with that. A judge, again, guides the process in order to make sure that the process is in compliance with the ethos and the judicial case management system. All right, so objectives of case management. Let's have a look at rules 17 and 18. So overriding objective of the court. 17.1, the court must seek to give effect to the overriding objective referred to in Rule 1 when it exercises any power given to it under these rules or in interpreting any other rule of procedure or practice direction application in the court. Under these rules, the control and management of cases filed at the court is the primary responsibility of the court, and the parties and their legal practitioners must cooperate with the court to achieve the overriding objective. Now you can go to Rule 1 and you'll see sub-rule 3 in Rule 1. The overriding objective of these rules is to facilitate the resolution of the real issues in dispute justly and speedily, efficiently and cost-effectively as far as practical by ensuring that the parties are on equal footing, saving costs by, amongst others, limiting interlocutory proceedings to what is strictly necessary in order to achieve a fair and timely disposal of a cause or matter, dealing with a cause or matter in ways which are proportionate to the amount or value of monetary claim involved, the importance of the cause, the complexity of the issues and the financial position of the parties, and ensuring that cases are dealt with expeditiously and fairly, recognizing that judicial time and resources are limited and therefore allotting to each cause an appropriate share of the court's time and resources, while at the same time taking into account the need to allot resources to other causes, and considering the public interest in limiting issues in dispute and in the early settlement of disputes by agreement between the parties in dispute. And then the factors that a court may consider in dealing with the issues arising from the application of the overriding objective are set out in sub-rule 4. The extent to which the parties have complied with any pretrial requirements or mandatory or voluntary pretrial process, the extent to which the parties have used reasonable endeavors to resolve the dispute by agreement or to limit the issues in dispute, the degree of promptness with which the parties have conducted the proceeding, the degree to which any lack of promptness by a party in undertaking a step or proceeding has arisen from circumstances beyond the control of that party, any prejudice that may be suffered by a party as a consequence of an order proposed to be made or direction proposed to be given by the court, the public importance of the issues in dispute and the desirability of a judicial determination of those issues, the extent to which the parties have had the benefit of legal advice and representation, and any other relevant matter. So you can go back to those are the principles taken into consideration, and that is what informs judicial case management. Now, Rule 17, as I said, sets out the application of the overriding objective, and then the power of the court to manage cases is set out in Rule 18. A court may, except where the rules expressly provide otherwise, extend or shorten the period of time for compliance, adjourn or bring forward a trial or hearing, require a party's legal practitioners to attend the court or an informal hearing with a judge in chambers, schedule a hearing by telephone or email, or by using any other viable method of direct communication, take any step or make any order for the purpose of managing the case, direct the parties to cooperate with each other, identify the real issues in dispute, decide promptly which issues need full investigation and which may be disposed of summarily, decide the order in which issues are to be resolved, fix timetables for the progress of the case, separate the adjudication of interlocutory motions from that of the merits, give directions for the better, more practical and more timely production of evidence, give directions for the production or discovery of documents at a more convenient, practical and earlier time, determine as soon as practicable firm dates for particular steps as well as for trial or hearing of the case, order for sufficient reason that all or any of the evidence to be adduced at the trial be given on affidavit, subject to right of cross-examination. So you'll see that the court has wide powers, and essentially what I'm trying to say and what Rule 18 is trying to convey is that in all dealings with a matter, a judge should do what is possible in order to achieve the overriding objective, which is speedy, fair trial, equal footing, cost saving, etc., etc. Those principles become the overriding considerations when a judge deals with a case. Okay, the obligations of the parties in case management and in the judicial system. It's actually Rule 19. That's a mistake. It's not Rule 20. Rule 20 is the obligations, is the protective cost order. So just the obligations of the parties is not Rule 20. It's Rule 19. It must cooperate and assist in curtailing and limit interlocutory proceedings, comply with an order or direction, attend case management conferences and other hearings, comply with deadlines, use reasonable endeavors to resolve a dispute, ensure that costs are reasonable and proportionate, act promptly and minimize delay, disclose critical documents to each other at the earliest reasonable time, on receipt of critical documents, not to use the documents for a purpose other than in connection with the civil proceedings. So these are the obligations of the parties, because if the parties don't cooperate, then it really is going to delay the process, and it's going to hamper the judicial case management system. So essentially you need buy-in from the litigants. Of course, the court has powers in the sense that it can sanction, can issue sanctions and can hold parties in contempt, etc., etc. But the short and the long of it is, if practitioners don't act in the manner in which is set out in Rule 19, then it's going to have a whole serious implications for the judicial case management system as a whole. So as I've said, judicial case management takes place in 3 phases. Now, I've said here pre-trial includes ADR. Alternative dispute resolution is actually already between these 2 phases, between case planning and case management, depending on how the parties agree and depending on whether the parties agree to first exchange pleadings and make discovery and or witness statements and then proceed to ADR, or whether it's actually right at the start when only summons is issued that the matter proceeds to ADR already at this stage, but it's somewhere between case plan and case management. So we can actually say, now what the court has done, ADR is not for all cases. There's a list of cases that must be referred to arbitration, to alternative dispute resolution, and that would be matrimonial causes, contractual claims, etc. Certain matters don't need to, building contracts, etc. Certain matters don't need to go to compulsory alternative dispute resolution. There the parties have the choice. So parties don't need to go, but they can. They can request and the court can order that. Once the court orders court-connected mediation, that would be set down before a court-connected mediator, who is someone who underwent some training and who understands the mediation process. That party doesn't act like a judge or even an arbitrator. A mediator is something completely different. So a mediator would be someone who talks with the one party and then alone, and then goes and speaks to the other party, then says, I don't think you have a case. I think you should reconsider, and then goes back to, so I've told them that they don't have a case, but please bear in mind that you have issues here with this, that, and the other. Then they would say, yeah, but what about this? And then I'll go back. Then I'll have the parties in one room, etc., etc. And that is in order to facilitate a settlement between the parties. It's a very effective system. It's led to countless settlements of matters which would have proceeded to court otherwise. I've personally walked into a mediation in a matter of about 300 million, claim of about 300 million. It settled within 2 hours. We were ready for a big fight, at least 3 weeks in court. Settled 3 hours. 2 hours, sorry. So it's effective, it works. It's not to say that if mediation was ordered here at this stage, particulars of claim is filed and the matter goes to ADR here already, or to mediation, and it doesn't, mediation fails. That's not to say that the parties won't be able here or even here to again attempt mediation. I've done that. Matters that haven't settled here, for particularly the example I gave you earlier, the filing of the witness statements in the divorce, the husband who was a terrible father and husband. So he was very confident about his claim here, and then here he said, ooh, maybe I'm not in such a good position anymore, maybe I should reconsider what I'm busy with, and the matter settles here. So this happens. Whether the court will continue wasting court time and money on ADR for a matter which already failed, it's questionable, but the parties can certainly say they'll pay for it themselves. That's then ordered. So that's the purpose of mediation. So understand that a mediator cannot act for any one of the parties ever. The mediator is not an unbiased person. In fact, the mediator must get involved with the parties. The mediator must speak to parties. You would never have an arbitrator or a judge speak to any party while the other party is not present. That happens often in mediations because that's how you, as a mediator who's knowledgeable in the law, knowledgeable of the matter, you have your mediation briefs prepared so you know what the matter is all about, and you are able to assist a party in saying, I don't think you have a case, or you are weak here, you're weak there, I think you should settle, and then settlements are. And that obviously relieves the court of the burden of cases that goes through the court rolls. So there's method to the madness. It's not simply because we want people to make love and not war. It's because we want to alleviate the pressure on the court rolls of matters that can settle and should settle at the start and shouldn't further congest the court rolls. Okay, Rule 38 and Rule 39 deal with ADR, deals with the procedure and the obligation of the parties, and the practice directions then set out which matters are to have to go to ADR and certain don't have to. Because they are forced to go to ADR, the parties don't have to pay for it. That's why there's a mechanism such as court-connected ADR, court-connected mediation. Of course, the parties can also agree in terms of ADR for the matter to be referred to arbitration, private arbitration. In fact, the parties can at any time agree for a matter to go to private arbitration and then ask that it be stayed. Okay. No, arbitration must be successful. Arbitration is like a trial, but it's before an arbitrator. Award must be given. The arbitrator must give an award. So arbitration is different from mediation. Mediation is someone walks around and between the parties gets them together and tries to get a settlement out of them. Arbitration is a trial proper. It's just not in the court. It's before an arbitrator who acts as a judge. And that arbitrator can be an engineer, for instance, in a building contract. It can be an accountant or an auditor. So the parties agree to and appoint an arbitrator, someone, maybe the president of the law society or whatever, and then that arbitrator conducts a trial. The parties agree on rules and procedure and exchange of pleadings, statement of claim, statement of defense, etc., discovery, all of that. Witnesses are called to testify, and then an award is made. And then the arbitration award is made in order of court. So one party wins and one party loses. That would have to be with leave from the court, and the court will not easily grant that relief, I can assure you. So once the court has sanctioned that the matter proceed to private arbitration on agreement between the parties, you will have to have very strong grounds on why you want to proceed back to court. So what happened, for instance, in a matter that I was recently involved in, is it was a building contract, and there's an arbitration clause. So the plaintiff issued summons in the High Court. The defendant raised the issue of the arbitration clause. So the parties agreed that the matter should proceed to arbitration. Then the defendant just simply delayed, because in arbitration it doesn't have the same bite in terms of the procedure and getting everything ready. So as a result, the plaintiff had no choice, went back to court in an application to say, well, I've tried my best, but this person is not even cooperating in the appointment of an arbitrator. So this shouldn't proceed to arbitration, let's just proceed with the trial before court. So yes, but in that circumstance, if the innocent party says, well, I don't know what else to do because this person isn't coming to the table, coming to the party. Whether a party who is just thinks that maybe I made a bad decision, I actually prefer the court, whether the court will take that into consideration is highly questionable. Yeah, the courts there would have to be special circumstances, like the instance I've just explained to you, where the one party is simply frustrating the progress of the arbitration to the extent that one party is being prejudiced thereby, then absolutely. So if a matter goes to private arbitration, there's no arbitration through the court, so you need to go to arbitration, private arbitration, but then the case in court is stayed, pending the outcome of the arbitration. The arbitration award is final, and whether or not it's subject to appeal to the High Court would be something that must be agreed between the parties. But an arbitration award is final and binding. All right, that concludes arbitration and ADR, so I'm ready to proceed to the next slide. I think let's just take a 5-minute comfort break, and I'll see you all back here 20 past.